All right, I need to take a break. This man right now is having a stare down with me.
What's going on, y'all? Attorney Tom here. In today's video, I'm going to be reacting to the Darrell Brooks trial. For anybody who doesn't know, Darrell Brooks is the gentleman who drove his car through the Waukesha, Wisconsin parade, killing and injuring dozens and dozens of people. His trial just concluded, and it was a doozy. In today's video, we're going to be going over a bunch of odd situations that occurred in the trial and seeing if there's anything we can learn from this scumbag.
I'm sorry, go ahead.
I would like to represent myself pro per.
What does that mean to you, sir? Explain to me that request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
So you heard that right. He said the magic words, sovereign citizen. In the pretrial hearing, Mr. Brooks decides to represent himself. He announces he's going pro se, and he's going to follow the sovereign citizen playbook. Now, many of you might be asking what exactly the sovereign citizen playbook is. Well, it's basically a bunch of nonsense. For instance, he likes to think that if he turns his back and pretends like he can't hear what's going on, it somehow excuses him from any sort of consequence.
At 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items.
So if you listen to clips throughout this trial, you'll notice that the judge is often articulating what's happening. That's because she has to make a record. Most times, in most cases, there aren't camera systems like this. So the only thing that matters is what is written down. So she has to announce for the court reporter to write down all of these things.
Do you see the driver of the red SUV in the courtroom here today, Officer Schneider?
Objection, hearsay.
Overruled, she may answer.
So hearsay is an out-of-court statement made for the truth of the matter asserted. If you have a first-party witness, somebody who witnessed the event, and they are on the stand testifying, it is not hearsay to ask them to identify somebody, especially somebody who's probably in the courtroom. What would be hearsay is if the prosecution was trying to get that officer to state a statement made by somebody else outside of court. For instance, if the question was, "Officer, your significant other told you that they saw Darrell, correct?" That would be hearsay because you could just get the significant other in court to make that statement. You don't need the second layer. This is not hearsay.
Yes, Mr. Brooks be directed to remove his mask so that Officer Schneider can identify him, please.
Objection, I never heard an answer to the question.
It has not been answered, Mr. Brooks. Please remove your mask.
Additionally, I'm going to make this point. Obviously, in this case, Mr. Brooks is an extremely unlikable person. However, I've seen lawyers fall victim to this as well if they try to play too many games. There is such a thing as objecting too much, even if you are technically correct, which Mr. Brooks is not. I cannot emphasize that enough. He is not. But if you object too much, you just look like a jerk. And remember, it doesn't matter if you're right if nobody likes you.
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now,
Okay, y'all, so generally, only experts are allowed to give their opinion on matters in court cases. I do not know if this individual is an expert or not. Sounds like he's a fact witness. However, if you are cross-examining somebody and your question literally asks for an opinion, it's just a bad question. You're opening the door for that. Here, Mr. Brooks said, how did you come to that determination? Opening the door for this guy to give his opinion.
asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
See, this is the problem. These sovereign citizen people make me so annoyed because they think that's a gotcha moment. Oh, you don't know for sure if the guy was angry. Well, you can infer from the circumstance, and also it's a credibility thing. Are you going to believe this guy as credible, or are you going to believe the guy who's outbursting during court?
Down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense. And is
Okay, so what's going on here is Mr. Brooks is about to put his ex-girlfriend on the stand, the mother of his children, and basically say that she's a bad mother and she's a lot of the reason for the problems that are going on because of some instances in her past. Now, in order to address Mr. Brooks's claims that the mother of his children was the bad influence, if he brings up those things, they will be forced to open the door to discuss his past as well, which includes some prior criminal convictions. Now, generally, past criminal convictions of a different nature are not admissible in a criminal trial because they're irrelevant and you don't want to unduly prejudice the jury. But if you're a lawyer or a pro se defendant, you can't have your cake and eat it too. You can't talk about things that would otherwise be inadmissible or irrelevant for your case and then not expect the other side to combat that. And that's what they're arguing about here. Let's keep watching.
offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
no,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much, did you know she said she was 18 when I met her?
Okay, on top of being a total piece of shit who murdered a bunch of people, Mr. Brooks is just wrong. He is so wrong. He has a fundamental misunderstanding of the law. He was just arguing about his statutory sex crime that he was convicted of because he impregnated his then underage girlfriend, saying, quote unquote, "Do you know that she told me she was 18? The word statutory negates all mens rea, meaning it doesn't matter what she told him. She could have given him a fake ID that would have said she was 30 years old or whatever. Statutory doesn't matter. He's just so wrong on so many things. I hate this guy.
I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
Bruh.
That's not how it was said.
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks.
So I'm the only one. I got one.
Mr.
I got
Brooks.
one ear that work, and I heard that.
This
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me.
This guy's acting like a toddler. I mean, what? I don't know what else to say.
You should be informed that you have the power to nullify any law that you don't agree with.
Objection. Statement.
Okay, so he just brought up jury nullification in the closing argument. You cannot bring up jury nullification. What jury nullification is basically the jury's understanding the law and applying the law and just completely disregarding it and doing whatever they want. The fatal problem that Mr. Brooks has run into, obviously other than the rules of evidence where you can't talk about jury nullification, is nobody's going to nullify you if you're a piece of shit. How do you think the jury thinks after hearing this entire trial, all these ridiculous antics, they're going to throw the book at you?
But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection. Misstatement of the facts. Facts not in evidence.
Was in fact.
Improper argument, Your Honor.
Sustained.
Okay, so generally during closing arguments, it's fair game. You can make an argument, you can say whatever the hell you want, as long as what you were saying has a basis in the evidence that was presented during the case in chief. Here, Mr. Brooks is magically trying to pull out of his butt the fact that the Ford Escape was recalled, and therefore that is what caused him to drive through the crowd, and that wasn't in evidence. You can't just create things for the sake of a closing argument. And let's be real, y'all. By this point in time, even if nobody objected to this, nobody's going to believe a thing this guy says.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson.
And remember when I said they were going to throw the book at him? Well, they did. The jury convicted him of all counts. There were like 75 or 76 counts in less than 3 hours. That averages like 2.5 minutes a count. If any of y'all have ever been on a jury, just reading the damn sheet takes 2.5 minutes per count. And the last thing I want to talk about, which is very important, is the judge. I thought she did a fantastic job. I saw a lot of people commenting online saying, oh, she should have been stronger. She should have thrown the book at him. She should have thrown him in contempt more. She should have done more things. No, she purposely stayed calm even when I wouldn't have and normal people wouldn't have, because she needed to preserve the case. She needed to preserve the integrity of this case. She kept calm. She made good decisions. She kept a clear record. And she acted in the way she did in order to preserve the integrity of the trial, because if she had an outburst or got upset at the defendant after she was called names or blatantly disrespected in the courtroom, that could have resulted in a mistrial, and a mistrial would cost the taxpayers millions of dollars. Plus, it would hurt the integrity of the court. It would give off the opinion that she was biased because she let her temper flare. And so, in my opinion, she did a great job, because I know I would have lost my temper. I would have got more upset at Mr. Brooks.
What did we learn? Don't be sovereign citizen. Don't be proper/say. A bunch of legal definitions.
All right, y'all, that's it for today's video. Bye.